Hi, it's attorney Peter Olson here. I want to talk about three big mistakes that I see many people make, and even some of our clients making, and just how to avoid them. And these are mistakes in parentage cases where you have parents who aren't married and dealing with the issues related to their child or children. The first big mistake I see people make are fathers who sign off on the parentage of a child without requiring DNA testing. The Illinois Parentage Act requires or allows a father to get DNA testing through the court system, but way too often I see people who don't get that done. They sign off on a parentage of a child, and too often after the fact it's found out they're not the father, and it's really hard, if not impossible in most cases, to get out of that parentage finding after the fact. So that's one big mistake, not requiring DNA testing in parentage cases. The second big mistake I see too often are people, a father or a mother, who let the other parent leave the state of Illinois with a child. And our law right now is that that other parent, the parent in possession or custody of a child, must get court approval to leave the state. So we've had cases recently where we've been able to get the child brought back to Illinois. But here's the problem. Sometimes a parent is out of Illinois too long, like more than 6 months. And if it gets to be more than 6 months, sometimes the new state, let's say California, now becomes the home state of the child, and now that state has jurisdiction over the case. So at that point, there's nothing Illinois can do. So that's the second one. Waiting too long, letting another parent get out of Illinois for too long. And then finally, a big money issue is retroactive child support, and this is with fathers. And the issue here is this. Most times you'll see a parent, typically a mother, bring a parentage case and a child support case with it. When a child is 2, 3, 4, sometimes even older. In other words, they're usually not brought right when a child's born. And here's the problem that I see fathers run into. That period, the mother's entitled to retroactive child support from the date she brings the case. Let's say the child's 3 years old, going backwards to when the child's born. And that's a long period of time in some cases. And what happens is fathers just take it. They don't defend that time period. And usually, in my experience, a lot of times the parents had been living together, or the father really had been buying a lot of things for the child and stuff, but they just aren't prepared to defend themselves. And too often I see big judgments, like $10,000, $20,000, $30,000 entered against fathers for retroactive child support just because they're not ready for it. So those are three big mistakes that I see people making in parentage cases. So if you're in a situation like this, or you know somebody who is, please get in touch with me, 312-629-9900, and maybe I can help you out. Thanks.